Welcome to the Dynamist. I'm Evan Swartztraber. Mark Meador is the newest commissioner on the Federal Trade Commission, an agency we've discussed quite a bit on the show. The FTC has a dual role, enforcing both antitrust and consumer protection laws, and it often serves as America's de facto regulator of technology, issues like digital privacy and cybersecurity. Meador is in many ways a manifestation of the political realignment that has been reshaping conservatives' views on everything from big business to capitalism to free trade. The Trump administration's antitrust investigations and cases against big tech are perhaps the most prominent example of how that realignment is expressed through antitrust enforcement. Wall Street, which seemingly can't get enough of mergers and acquisitions, had bemoaned the tough stance toward M&A under the Biden administration. There were many in the financial chattering class who hoped that Donald Trump's return to office would mean a return to the laissez-faire approach on antitrust that had dominated for decades. But then Trump disappointed them. He elevated Andrew Ferguson to be chair of the FTC, and he nominated Gail Slater to lead the Department of Justice's Antitrust Division. And the third gut punch, or win, depending on your perspective, was the nomination and confirmation of our guest today. But we're not just talking about a handful of isolated cases against tech giants like Meta and Amazon. Meador recently gave a seminal speech called Antitrust Policy for the Conservative, where he outlined a comprehensive worldview on these ideas. Critics have already framed his remarks as a radical departure from long-held conservative beliefs about free markets. But Meador argues that he's simply advocating that conservatives return to their roots and rediscover the anti-monopoly underpinnings of their movement, going all the way back to America's founding fathers. Today, we'll get into the tensions at the heart of this political realignment. Can free market beliefs coexist with strong antitrust enforcement? How do skeptics of big government align with skeptics of big business? And how can conservatives differentiate their approach to antitrust from the left while still celebrating the bipartisan support that antitrust has enjoyed over the past 8 years? Mark Meador was sworn in as FTC commissioner on April 16th of this year. He recently worked in private practice as a lawyer and visiting fellow at the Heritage Foundation Tech Policy Center. Prior to that, he served as deputy chief counsel for antitrust and competition policy for Senator Mike Lee. He's a Republican that represents Utah in the U.S. Senate. During the first Trump administration, Meador worked as a trial attorney in the Department of Justice's Antitrust Division, and he began his career as an attorney in the FTC's Bureau of Competition. Commissioner Meador, thank you so much for joining the show.
Thanks for having me. It's great to be here.
And welcome back to the Dynamist.
Yes, great to be back.
You were in a different role when you were last here. So I want to start out with the question that a lot of folks have been asking. They see this continuity from the end of the Trump administration, the 45th presidency, through the Biden administration, and now again with the current Trump administration. And people are wondering, what are the differences between the two presidents' approach to antitrust? And when we had Chair Khan on recently, former chair of the FTC, I mentioned to her, of course she knows, right, that the Wall Street Journal editorial board ran so many pieces against her during her chairmanship. And now your chair, Andrew Ferguson, has that honor of having a piece criticizing his approach. You know, there's a headline, I'm looking at it here from a couple weeks ago, is Lina Khan back at the FTC, right? The editorial board of the Wall Street Journal is lamenting that it seems like there's this continuity. So for casual observers who see all these big tech cases continuing, just rhetoric around strong antitrust enforcement, am I just interviewing Lina Khan again, sitting across the table from me? Or what is the difference between your approach and hers, or Ferguson's approach and hers?
No, it's a great question. I'll preface all my remarks by saying I'm only speaking for myself, not any other commissioner or the Federal Trade Commission. But I think that's a really important question. To start with the Journal, it's been frustrating. I think they've become a bit of a resistance rag for the financial elite, which, they're free to do, but they're kind of fading into irrelevance. But look, there's two groups they really don't like, and it was Lina Khan and Donald Trump. And so it's not surprising that they're attacking both of those groups. That said, there's some really important differences. I understand some of the continuity between the last administration and ours. I think some of the things people have pointed to, it's amusing because a lot of the greatest accomplishments from an antitrust perspective of the Biden administration were continuations of investigations in cases that began under the first Trump administration. So in that sense, you do expect some continuity. And obviously, we're very excited to see those cases across the finish line. But there are some really key differences that people should expect. And a lot of it comes down to procedure and the rule of law. So one of the things that was most frustrating to see as an antitrust enforcer, a former lawyer at the time, I was on the Hill for much of the Biden administration, and working for Senator Lee, as you mentioned, and we had lawyers in private practice reaching out on a pretty consistent basis saying, what's going on? Like, help us understand. And there was just a series of events that really created concern that antitrust enforcement was being not just invigorated, but politicized to the point where the process was the punishment. So we saw things like at the very beginning, they stopped granting early termination, right? So this is when companies file HSR filings when they want to do a merger. There's a period of time for the government to review so they can take a look before they're closing and decide whether to bring a suit. And a lot of those filings, there's no concern present, and it's obvious from the get-go. And so the agencies will say, you know what, we're going to terminate the waiting period early. Go ahead and close. There's no need to make you drag this out. And they just stopped doing that for no reason. They said
wholesale, like no exceptions.
No exceptions. And supposedly it was about resources, which I don't understand. If you're reviewing these mergers anyway, once you know there's not a problem, why not let them close? You're not actually saving any resources by making those parties wait longer. So there was that. You had deals where the agency didn't take an action, and then they would send a warning letter to them saying like, oh, we didn't sue you, but we could in the future. And everyone knows that, like that's the law. Choosing not to sue before a merger closes does not prevent the agencies from bringing a lawsuit later if we learn additional information.
Right. For example, Meta closed the acquisitions of Instagram and WhatsApp and is now in court over those very acquisitions because over time, the agency said it became anti-competitive.
Sure. And sometimes you have mergers that aren't even required to file under the HSR Act, and we learn about them later. We can still come in and stop those or undo them where it's appropriate. So everyone knew that, but going that extra step of sending these letters to sort of wag the finger caused a lot of businesses to have some heartburn, understandably, and to be concerned, like, what are they going to come after me later? What's the deal? Everyone felt like there had been a process and that they knew how to navigate the process, and there was some expectation of predictability and transparency, and that it seemed like that was going out the window. And then it got worse, right? So I had private sector attorneys calling me and telling me stories of, they represented parties with a merger that really had no issues. No one ever expected it would attract attention. They would get a second request. That's where the government sends essentially a subpoena and says, we want a bunch more information because we think there are concerns here. And the lawyers would call the FTC attorney and say, can you explain what the theory is? Like, what's your concern? What's the possible harm? And the staff would say, I have no idea. And they would go back and look at the second request that was sent as a Word document rather than PDF for some reason, and look at the metadata and see that these documents had been edited by people in the front office, and it was done 5 minutes before it was emailed out, right? So there was this impression that this wasn't staff conducting investigations on a good faith basis based on the merits. The front office, the political appointees were reaching down into things like second requests after an HSR filing, editing those requests themselves and basically forcing staff to send things off. Other calls of from attorneys talking about conversations with staff in the early days of the Biden administration, where they were almost apologetic. It was sort of like a, blink twice if you need help sort of situation, where they're saying, look, I don't understand the theory here, but I've been told to tell you, we're looking into this. No, I can't tell you more. No, I can't explain what the concerns are, but I have to do this. So that was really concerning, and it, I think, reflected this view that mergers are presumptively bad, right? So that's a big difference, I think, with this administration. We are not of the view that all mergers are bad. Chairman Ferguson has done a really good job of making explicit that if your merger is anti-competitive, we will go to court to block it. And if not, we're going to get out of the way. We're not interested in trying to just slow down the flow of mergers across the board. The fact is the vast majority of M&A is helpful for the economy. We tend to think it's a closer divide just because you really only hear about the ones that are controversial, that potentially pose a problem. But there are thousands filed every year that don't even get a second look. So that was really frustrating. I think it did a lot of damage to the FTC's reputation. It created unnecessary delays and expenses for industry, and nobody really won from that. So I think that's a key distinction in our administration is that we're going to enforce the law, but we're going to do it as professionals and grown-ups. We're not going to be going around with this sort of cult of personality, chasing headlines. That was another big concern that we saw, right, is that some of these enforcement decisions really seemed driven by How can we get some good press? And at times at the expense of the law, right? And that
is there a case you would cite as an example of one that maybe the agency should have known it didn't have a very good case, but it was a headline grabber?
So, I mean, there's some stuff that's still open that I can't talk about. There was the Meta within case. I think that's been fully resolved.
And that was just to...
Yeah, that was Meta was buying a virtual reality app developer, and the FTC said that it was concerned about a potential competition issue. And at the end of all that, after the government, i.e. taxpayers, and the parties had spent millions of dollars litigating, going through the whole process, you get a decision where the court says, yeah, the theory is sound, but the facts just don't match it, right? And they should have known that from the get-go.
Okay.
And so you've wasted millions of dollars in agency resources, court resources, the parties' resources. It's just a tax on everyone. And all you've done is get a court to say, yeah, the law is what you said, but you didn't prove it.
So
right? And then you risk, right? The bigger thing is you've risked getting bad law. Mm-hmm. So an incredibly risky proposition for no gain. Yeah.
When Chair Khan was on this show and addressing some of her critics, she pointed to statistics showing there wasn't this drastic decrease in M&A during the Biden administration. Are you saying that some of these hidden activities or mergers that were maybe abandoned or never filed because of the process, would that not be reflected in the statistics she's citing? Because that she makes a case that, just look at the numbers, right? There wasn't this massive downturn. We weren't hostile to M&A. All of our cases we filed under the consumer welfare standard. We talked about that, even though maybe there was some rhetoric in the press around revolutions and antitrust changing the standards. Is the argument that there was a downturn, you just didn't see it?
It's possible. And you don't know what you don't know, right? So we'll never know which deals weren't filed. I think there was also an expectation as we came out of COVID that we'd see a much bigger surge. I think the word on the street has been that a lot of capital was just sitting on the sidelines. The message was delivered early on, and then people were just kind of sitting out and waiting to see how things progressed. But it's hard to know what never happened because we have no insight into that.
Okay, so we've talked about this a lot. FAI sponsors a podcast called The Realignment. This is a very typical topic on this show. There was a phenomenon during the Biden administration called conservatism. And this was a play on words with Lena Khan and conservatives, obviously, if you didn't pick up on that. And there were a lot of young conservatives who were drawn to her message of, look at the harms of consolidation, not just in tech, but in agriculture, healthcare, other industries. And despite Lena Khan's background, right, Yale law student, it's about as progressive as you can get, that community, and some of her writing, and she's clearly a Democrat. She was nominated by a Democratic president and was some of her allies on the left were, Bernie Sanders, Elizabeth Warren, right? Not conservatives. You still saw this phenomenon. Why do you think that was the case, that she drew so much support from the conservative movement, even though you just made a very, articulate case that there's some non-alignment there? And how does that fit into your broader perspective on where we are now as a conservative movement, getting into some of the themes of your speech that we'll unpack in more detail?
Sure. Well, one, I think it was a little overblown. I think that it was mostly folks in the left advancing the conservative narrative. I think it was helpful to their project, right, to portray the right as being fully on board with everything they were doing. The fact is, there's been some serious disagreements. And I had sort of a front row seat on the Hill to a lot of that during the Biden administration. And I will say it was a frustrating experience, right? So there was a lot of interest around legislation on the Hill. There were some bills that probably could have moved, but different people had different priorities. And there was a lot of frustration from those of us on the right that this whole realignment project didn't really feel like like a realignment, right? It was more like the progressives were saying to the right, hey, you're free to come along and join our project, but we're not interested in your feedback. We're not interested in your input. And you saw this in the legislative battles, right, where conservatives would chime in and say, hey, I like the general thrust of this bill, but I have some real concerns with how it's implemented. Here's my red line. Here's how I think you can improve it. And we were basically told, yeah, thanks. Okay. Anyway. And And the message was, if you want to support us, that's fine, but we're not interested in actually hearing what you think. And to get to the other part of your question, I think part of this is, for the younger conservatives that were looking at this and thinking like, oh, I should support the progressives on this side, it's because there was no alternative. No one had really laid out a vision for, in the antitrust context, what does it look like to be a conservative who supports strong antitrust enforcement? What can we agree on and where do we disagree, right? And so, look, I still think there is directional similarities, right? I think there are people on the left and the right who both want to see antitrust enforced in a more vigorous way to tackle the challenges of big tech and other industries where we have high concentration and low consumer satisfaction. But we're still conservatives, right? We're still concerned about limited government and the exercise of government power and giving judges too much discretion, right? All of these things. And so we're going to want to address these problems in a different way, perhaps, right? We're not as interested in bright line rules that might, stop good mergers or prevent good conduct. We're going to want to try to go down the middle. But we can kind of thread this needle. I think, to kind of get into some of the stuff that I was getting at in my paper, there's a real argument to be made that the neo-Brandeisians and the Chicago School are two sides of the same coin, right? They both essentially want to have an excessive deference to a single side in an antitrust case. They just differ on which side that is. And that's where I think we start to get into this realm of politicized antitrust that people complain about. Now, at a certain extent, people complain about politicized law enforcement all the time. Policy is always going to be somewhat political, and the etymology explains why. But when we talk about politicization in a pejorative sense, what we're getting at is that it's unfair or it's rigged. And I think that's what, I think people in my position have concerns about, right? That the approach of the neo-Brandeisians at times seemed rigged so that the government always wins. And the approach of the Chicago School at times seems like it's rigged so that businesses always win. Both of those seem excessively politicized to me. And what we want is that neutral approach down the middle. It says, no, we're going to take the law seriously. We're going to apply the text as it was written by Congress. And we're not going to just always assume that businesses are acting innocently, but we're not going to assume that they're always acting malevolently, right? It's a case-by-case situation. You can't have a one-size-fits-all approach. And it tells you how poorly things have gone that both sides criticize that view, right? That people on the left are going to say, that's just an excuse for business. And people on the libertarian end are going to be like, you're a radical, right? And that's kind of when you're in the sweet spot, when everyone's mad at you, you're going down the middle. But that's what I think a neutral and fair application of the law looks like. That's what the rule of law looks like. That's what sound enforcement looks like.
So I came of age in DC in libertarian world, right? And I had the pleasure of watching your speech in person recently.
The pleasure or the burden.
Yes, exactly. And your speech was really kind of you laying down a marker, like this is how conservatives should think about antitrust. And the 22-year-old version of myself, if I were in that room, I'd be like, oh my God, he's stepping on third rails. He's saying these things that are, we just know not to be true. And one of them, which already sparked, a critique in Reason Magazine, which is like the Libertarian Bible, you suggested in the speech, you argued very articulately and strongly that economic power can be as much of a threat to liberty as government power. And the libertarian would say, well, what are you talking about, right? Economic power, no matter how powerful it is, it came about because of voluntary transactions and contracts and investment. Government power is because the government has a monopoly on the use of force, right? And they could put you in jail and they could lock you up or shoot you, right? So those two things just cannot be equally dangerous.
Yeah,
so
to jump in there, I think the recent years have just proven that flatly wrong. That is not the lived experience of millions of Americans. How many people out there would say that they have, free equal bargaining leverage with their bank or with companies that service their email or photo sharing or communications? That's not the world we live in, right? Where they're voluntary in the sense that like no one's pointing you at the tip of a gun to go, use this company or that. But there are very large businesses that have an immense amount of power over multiple facets of our lives in a way that human society hasn't experienced before. I think a lot of this did kind of come up in 2020. And, to get back to our discussion about sort of changes on the right, and whether this is really just about censorship, right? Because we do hear that a lot, that conservatives are just mad about censorship, and that's what this is really all about. And I think that's a very convenient argument for certain parties to make, both among tech companies and among other businesses who want to say, well, this is just really about censorship, but we can just make them feel better about that, then we can all carry on.
Yeah, we could change our content moderation practices. And
right, or like we'll throw some money this way and just basically buy them off. And like, I mean, to be frank, it's insulting, but it's also just wrong, right? I mean, factually wrong. What happened was you did have a lot of conservatives have this sort of like awakening moment, which I know sounds awfully close to woke, but that's not what I mean. But they had this sort of like their eyes were opened because of the bad acts by certain tech companies. And they saw that and said, well, this is bad, right? Obviously, like this is wrong. This is not good. And then you have to go through this whole process where like, but hold on, because I really believe that free markets don't lie. They reach the best outcomes. You know, businesses should be free to do whatever they want. And yet I am personally experiencing the acts of a large business acting against my self-interest and what's good for me and what I think is actually good for society. And it caused a lot of people to step back, right? And so it was the starting point, right? I think censorship issues really kicked this off, but then it unfolded from there, right? And you had conservatives stopping and saying, well, if this company can harm me, what about these other companies, right? You see that with the debanking issue, right? With large financial institutions removing people's accounts willy-nilly because they don't like what business they're involved in or statements that they're making online. Thank God we have more of a liberty culture in the United States. It's even worse overseas. But all of that sort of snowballed and caused conservatives to step back and say, maybe I've been ignoring a problem that's actually far more pervasive. And when that happened, it's like the scales fall from your eyes and they start to see things that a lot of us have been saying for years, which is, like free markets are good, but they're not self-perpetuating. The interests of many large companies are to try to dominate the free market and control it. Like that's the profit maximizing output. We want companies to be profit maximizing, but we have competition enforcers to maintain the guardrails, right? That's the role of antitrust law, is to maintain competitive markets. That's the only way you have a free market. And a free market is what's supposed to prevent bad outcomes like a few giant companies that are engaged in censorship. Right. When you have options, you can go elsewhere. Senator Lee is really fond of making the point that companies that felt competitive pressure wouldn't treat their customers this poorly. Right. And so that disconnect between I don't feel like the company is responsive to what I'm looking for in the marketplace and being told, well, it's a free market. What can you do about it? That disconnect and that tension is really what drove a lot on the right to say, maybe this whole system isn't running the way I thought it was. And maybe we've been asleep at the wheel when it comes to antitrust enforcement that could have prevented or mitigated a lot of these problems.
So another comment you made in your speech that this Reason article picked up on was that you said, big is bad. When referring to the size of the government or political power, this statement is not only uncontroversial among conservatives, it is axiomatic. And then you go on to continue, you say, to insist that just because a business is economically powerful does not mean it will behave badly is akin to expressing surprise that a gambler would place a risky bet after you gave him unlimited chips. So I think this gets at another tension, because even conservatives that welcome this realignment and everything you just said, they might balk at the suggestion that bigness is inherently bad, because that, getting to what we just discussed with the Biden administration and what maybe made their merger enforcement political, is that the cases they brought to court, maybe they argued under very traditional theories and didn't try to radicalize everything through the courts. But what you were discussing, what Chairman Ferguson has discussed, there was this like process stuff behind the scenes that was designed, however unintentionally or intentionally, to grind M&A down, to slow it down. And the presumptive motive there is, even if a merger is legal under the law, I'd rather see it not happen, because my worldview as a neo-Brandeisian or a populist leftist or whatever is that concentration is inherently bad. Right. And that's the difference between conservatives and liberals, but big is bad. So I guess help me understand how that's different than the critique of the left, which is that they're just trying to stop all M&A.
Well, I mean, I think you can't dismiss the rule of law point, right? That the conservatives do approach this from, certain things can be very concerning. That's different than them being illegal. We are absolutely not saying that being big is illegal, or that having a monopoly is not illegal. You have to act in an exclusionary way to maintain or create the monopoly. That's an important distinction to maintain, and because that is the law, we are not going to circumvent the law and use process to punish a bunch of people we don't like. But also, I had extensive remarks in there, and it all has to fit together. I talked about how, big is bad. That's a statement that we agree with as conservatives when we're talking about big government. And then when we apply it to economic power, we suddenly say, well, let's caveat this and what. And the point there is not to say that every big company is violating the law or immoral. The point is to say, when we're talking about political power, we're really concerned about bigness because we know there's a threat. When we talk about economic power, we should have the same skepticism. And I think it was Albert Cummins, who I quote in the paper as well.
And who is Albert Cummins?
He was a congressman, Republican, is the really important thing to state there. And he had a really good quote where he talks about, hey, in the political realm, it's entirely possible that if you had one monarch, they could run the government really well. They could be very fair and just, and it's certainly much more efficient than our divided form of government. But the American experience is that when you concentrate that much power in the hands of one person, it leads to tyranny. And his point was to say, we should have the same approach to business, that allowing that much power to concentrate in the hands of so few is more likely to lead to tyranny than to a free market. And so we should be equally skeptical there and on guard. And so that's really the overarching point, right? It's not about going out and demonizing businesses. It's certainly not about punishing businesses for being successful. We want to see that. But it's a recognition that as economic power grows, there's more cause for concern. There's more to be worried about, right? Like if you're zooming out to the international sphere, you're not worried about a country that has 1,000 people in their military. You're worried about the country that has millions and missiles and nuclear bombs and aircraft carriers, right? Like they're the ones that pose the threat. It doesn't mean they're going to do something bad, but you have to care about it more. If something bad and dangerous is going to happen, that it's going to come from those sources that have the concentrated power. So you have to pay attention to that. And the problem is that all of that makes sense when we're talking about politics and war and those sorts of traditional concerns on the right. We just, for some reason, then just shut down when it comes to economic power. And it goes back to what you're asking about. It's this idea that, any economic harm isn't that big of a deal. That's essentially what it's saying. And in the world we live in today, where we are all so intimately connected, technology has really shrunk the world. And so much of what we do on a daily basis depends upon and flows through giant national, multinational corporations. The effects of conduct happening in the business realm are not limited to a single business customer relationship, right? They have effects that ripple throughout the economy and therefore ripple throughout our political economy, right? And our government. It is all ultimately tied together. And so you can't just ignore one half of our society and say, we're not concerned with the abuse of power there because in theory, I could take my business elsewhere. Oftentimes you can't, and oftentimes by the time the harm is done, it's too late, right? You can't undo that. And so that warrants scrutiny. Then that's right. Then we come in as conservatives and we make the point to say, all right, that is a problem. That's the first step, right? We're pushing back against the libertarians to say, no, this really is a concern. We need to pay attention to it. And then, in the mold of trying to piss off everyone, we tell the progressives, but we're not going to go down the road you want to do where we're going to use all the levers of power to just crush everybody and flaunt the rule of law and the ends justify the means. No, one, recognize that it's a problem. Two, follow the rule of law to address the problem, right? That's what I think this administration is trying to do and why, we're going to get hate from the left and the right, and we're ready for it. Nobody really cares. We're here to enforce the law. That's what the president wants to do. That's what we're going to do. And it's going to involve pushing it back against both extremes to focus on consumers.
Briefly, I want to address something that you talked about in another podcast. I think you did in this very room with American Moment when you were, I think, out of government, however briefly that spell was. And critics on both the right and the left, critics of that lax enforcement period, let's call it. It's probably an oversimplification, right? But that like 1980 to 2020-ish period, the first Trump administration started to really turn the corner on that, and it happened during that first Trump administration. Critics of that period on right and left kind of agree that enforcers were more worried about a false negative than a false positive, or did I mix those up? False negatives. Basically, I'll without using the terms of art, they were more worried about blocking a merger that might not have been illegal than allowing illegal mergers to go through. And I thought this was interesting, and tell me if I'm way off base, but it seems like there's a reason why we might have different standards in an economic law versus like criminal law, right? So merger law, it says you can block mergers that may substantially reduce competition. That seems like a looser standard than convince a jury I killed someone beyond a reasonable doubt because the consequence of getting it wrong is I'm going to jail for the rest of my life, right? So, and is there a reason why in the economic context, we built in that wiggle room because we didn't want a situation where you allow 99 illegal mergers to go through because you were really worried that you might block a single one that was legal? Like, help me understand why it's important to maybe have that more of that flexibility and why people shouldn't be so concerned with, the potential for a non-illegal merger to get blocked.
Sure. So there's two reasons. The first is that on merger enforcement in particular, it's a forward-looking exercise. So it's inherently predictive to a certain amount. When you had the Clayton Act enacted, so that's what you were referencing with substantially less in competition. And it does say maybe substantially less in competition or tend to create a monopoly. So you have this incipiency is the term of art in antitrust. That we're trying to stop incipient harms to competition. And part of that was a response to prior to the Clayton Act, when you just had the Sherman Act, if enforcers were going to deal with a merger, you'd have to do it under the Sherman Act, which is really about an agreement. And there, you don't have an agreement until the contract is signed. And so merger enforcement is sort of after the fact. And then you have this whole unscrambling the egg problem and all of that. So part of the incipiency standard is really driven at, we want to be able to stop the merger before they close, so that we're not trying to undo something that's already happened, and sometimes that's not possible, so we can prevent the harm before it comes about. At a more policy theoretical level, right, and I talk about this in my paper, is this difference between, being primarily concerned about over-deterrence versus being primarily concerned about under-deterrence. And I think, if you look at the legislative history of the antitrust laws, the commentary at the time, it's very clear that there's a mix of motivations. Some of those are economic, like we want to make sure consumers are not being abused and forced to pay higher prices because of a lack of competition. Pretty straightforward. Others are more philosophical. It's like we think that concentrated economic power is a threat to democracy, which those are both valid. How do you balance that, and let alone how do you put this in the hands of a judge? This is where I think Bork got something really important right, which is that you can't have judges sitting there saying, well, I think this merger would harm democracy, so it's illegal, right? Like what does that mean? It's open-ended. It's obviously political. You're talking about balancing economic and other equities between various constituencies, which is a legislative task, not a judicial task. And so we don't want to allow that. So how do we strike this balance where we are protecting the economic functioning of markets in a way that furthers the goal of protecting democracy from concentrated economic power without allowing judges to actually get involved in that sort of fundamentally political process? And my answer to that is, well, we go back to being concerned about under-deterrence more than over-deterrence. And because that's what you see in the law, right? When you have these sort of incipiency standards, when you have this history of Congress passing the Sherman Act, courts kind of narrow it, Congress passes the Clayton Act, courts kind of narrow it, Congress passes the Kellogg-Fowler Act, courts kind of narrow. I mean, that's been the trajectory, and scholars have noted this, that like Congress keeps strengthening the antitrust laws, courts keep watering them down. And for a conservative, it's ironic, right? Like we love textualism, we love originalism. We've pushed for it in pretty much every legal discipline. except for antitrust law, right? Which goes back to like, we just thought businesses were great. We don't want to mess with them. So we're just going to ignore what the text of the statutes and legislative history actually says and go with this one policy because we like that as an economic outcome. But I think to balance those two goals of the antitrust laws, or two of the many goals, and to be faithful to the text, right, we need to return to following Congress's direction, which is to have an appropriate concern about under-deterrence, about under-enforcement, and that we can't just be assuming, well, we haven't stopped any mergers that would have been good, so that's fine, right? We need to make sure we're not letting through ones that are going to be bad. And it's not going to be perfect, right? You can't be perfect. I worry that our friends on the far left, right? Like they're so concerned about stopping every single bad deal, they're happy to just kind of stop them all, or like most of them. If we just grind it all to a halt, okay, no big deal. That's bad, right? Like that's really bad. We don't want that. It's hard work, but we have to go down that middle path. I saw someone on X recently complaining about, I think it was in the context of a major decision that came out recently, like, oh, isn't this so dumb that they had to produce millions of documents and do all these depositions just to like get through this process, and it was all dragged out. That's why we need bright line rules. It's like, well, yeah, but then you're going to end up with too many false positives, right? We're not saying that false positives don't matter. Like, we don't want to get it wrong. We don't want to stop things that are bad. But we've gotten to a world where we were so concerned about not stopping any merger that was good, we let way too many through that were bad, right? You could easily err in the other direction. And so that's, again, we're in this position, like we got to push back against both extremes. Both of those are going to excessively politicize antitrust. It's an overly ideological approach. It's just sort of black and white. And like, I mean, every lawyer will tell you, like, the law is not black and white. There's a gray area. You just have to do the hard work of applying the law to the facts.
So I'm glad you brought up legislation, because when you look at the amount of time that these recent major big tech cases take to litigate, it seems pretty staggering, especially given the move fast and break things ethos of Silicon Valley and the speed at which artificial intelligence is rolling out. One could look at these cases and be like, this is just not working at all, because even if you're pro antitrust and you're glad that the government wins a case, it's like, at what cost? And not to the business, at what cost in terms of time? So just to give listeners a sense of what I'm talking about here, the case against Meta that is ongoing was filed in December 2020, and the trial started last month. Okay. Google search, which the government won, filed October 2020, decided August 2024. We still don't have a remedy. We're still figuring out what is the remedy for Google's monopoly in search, maybe this summer. So 5 years, if at best case, right? Apple filed March 2024, trial, no one even knows when that's going to start, right? Could be years. Amazon, September 2023, trial will start October 2026. 3 years, maybe that's.
And these are all before appeals.
Yeah. It's like 3 years seems fast, I guess, compared to the Meta one, but like by what standard, right? And then you have private litigation, right? Epic Games, which makes Fortnite for all you with younger kids. Apple was told in 2020, stop doing this anti-competitive thing where you don't let people use an alternative payment system. 5 years later, they get hit with a contempt ruling for not complying. It took 5 years for a judge to be like, hey, stop flouting the law. So someone might look at this and just be like, even when you have 3 administrations in a row that favor vigorous enforcement, this is ridiculous. Like, we're not making any progress. The companies during these periods can just collect the fruits of their potentially illegal conduct, because we don't know yet until the judge says it's illegal. Why would they stop? Why would they stop collecting a monopoly rent? Like, why would they stop? So how do we speed this up? And does this just illustrate that instead of waiting for judges to apply 19th century laws to big tech companies that move very fast, maybe not as fast as they used to, but they still move fast, should we just be passing bills saying, you're not allowed to have a search monopoly? You're just not allowed. Like, if you have 90%, no more. You can't have more. You can't have 90%. Should we just pass a bill saying, you got to let everyone use your app stores. You got to let people have alternative, like Amazon, you just can't buy and sell on the same platform, right? Like there's bills that probably would address every single piece of conduct that is alleged in these cases. Is the length of these cases a problem, And should that be addressed through legislation, either by just saying that
Sure.
the conduct's illegal or throwing lots of money at agencies so that they can move faster?
So, a few thoughts on that.
Yeah.
One, obviously, Congress is free to do whatever they want, and I think it's common that you see law enforcement over a particular issue. Usually, after repeated cases, Congress can step in and say, "Okay, we don't need to have 5-year trials every time this comes up. Let's just clarify the law so that everyone knows. Don't do this." But that also does happen through adjudication, right? So antitrust cases are very complex and lengthy, and a lot of that is because there's, one, often a lot at stake, and two, we want to get it right? We don't want to cut corners, and so part of that is just the nature of the beast. But ideally, right, when you reach those decisions, now you have case law, right? And so in the way things are supposed to work is that then lawyers for other businesses can look to that and counsel their clients to say, okay, that was found to be anti-competitive, so don't do that, right? And so you shouldn't have to have, a 3 to 5 year litigation every time somebody engages in the conduct, right? What you want to see is somebody does something that has not been really considered before, or there's a new market, a new context. We're not sure how the law applies. Enforcers investigate. They say, we think this is anti-competitive. We think there's been harm to consumers. They sue to stop it. It's litigated. You get a decision, right? Now the decision kind of lays out the rules of the road for everyone else going forward. So there is that. I think that's an important process. Legislatively, it would be great if Congress could reenact some form of the Expediting Act, which would allow antitrust cases to kind of be fast-tracked to the Supreme Court. Then we could really clarify the law faster and provide more certainty. But otherwise, Congress is free to look at these markets and say, hey, I don't want to wait for FTC or DOJ to have to spend years and years investigating this to determine whether it violates the Sherman Act. I see this conduct. I think it's bad. And they can make that political decision, right? Like, they're not bound by the consumer welfare standard or whatever. Like, they can balance political equities. That's their job. And so they're certainly free. And we encourage them, when they see conduct that they think is bad as a matter of public policy, they can sort of short circuit the antitrust process and say, no, we don't need a judge to figure out whether this is good or bad based on antitrust precedent. We have, as policymakers, have decided this is not good for society, and so we're just going to ban it, right? And so that would make it a much more efficient process, and that is entirely in their prerogative. And we're happy to enforce whatever laws they write for us.
So speaking of when you were first on this show, the only time you were on this show, you had fairly recently played a role in drafting the America Act, that's an acronym that I don't remember what it says.
Advertising Middlemen Endangering Rigorous Internet Competition Accountability Act.
Incredible. I'm always impressed with the way that
it's competition.
Recently, it's unrelated, but members of Congress introduced a bill about insider trading, and they called it the Pelosi Act. So, shout out on that one to whoever made that one work. But January 2023, the Biden DOJ sues Google for monopolizing the digital ad market. Your old boss, Senator Lee, 2 months later, introduces the America Act, which kind of deals with the same thing. Then we get that bill reintroduced 2 months ago. And then last month, the court ruled that Google was, in fact, monopolizing. This was the Eastern District of Virginia, DOJ Assistant Attorney General for Antitrust, Gail Slater. The court ruling is clear. Google is a monopolist and has abused its monopoly power, allows them to censor, deplatform, harmed publishers, right? These were a lot of the allegations. Just given that you've been following this really closely, you helped write legislation that deals with this problem. Is there anything you're taking away from this case? Any lessons learned that could apply to your current job, future enforcement? Do you expect maybe publishers are going to get a better deal now from Google, or is it too late to help them because this case took too long, right? Just any kind of thoughts on this case, given that you helped write a bill to deal with it, and now how do you see that bill potentially interacting with this ruling?
Sure. Well, look, I don't want to get ahead of DOJ, and they're working on this actively, so I'll let them, take the lead on it. But I do see it as, the judicial outcome as a validation of the project that Senator Lee was working on. that, yeah, there are real competition problems in this marketplace that need to be fixed. Potentially that legislation can serve as a template for some kind of relief in that case. Again, that's up to, the parties and the judge to figure out what makes the most sense. But yeah, it shows that like Congress can act too. If that bill had been passed prior to the trial wrapping up, it probably would have rendered a lot of it moot. It would also have the effect of dealing with this preemptively for anyone else that may be in Google's shoes in the future, right? So there's that value to legislation as well, is that you can write something that applies to everyone going forward that is addressed towards conduct, not parties. That's the one shortcoming in antitrust law, in all law, is that a verdict binds the parties appearing before the court and no one else. You have precedent, and so you have an indication of what will be found anti-competitive in the future. But if somebody says, I'm going to roll the dice, right, then enforcers are back in the position of having to spend the resources to go enforce the law and apply it to those parties as well.
You've seen some critics of big tech say these companies are so large and so powerful, some of their power rivals governments, and that they kind of act like it. And recently, I mentioned the Apple ruling, right? They were told in 2020 to stop doing something. They did it for 5 years. A judge now referred that conduct for potential criminal contempt. You've seen examples of companies engaging in what they call malicious compliance. For example, right, let's say the court says Apple and Google charging 30% of every commission or 30% of every subscription. Like, so you sign up for any service in the App Store, they take 30%. That's a monopoly rent. A judge either in the United States or legislators or governments in Japan, South Korea, they say, you got to stop doing that. And Apple turns around and goes, cool. How about 27% plus a credit card fee? And now you're actually paying more than 30%, right? And for people who don't believe that government can really do anything to improve their lives, right? They might look at that and just be like, what's the point, right? Like they lose a case.
Well,
and they act,
you look at that and then tell me that government is more powerful than business.
Right? But what does it say if a company feels comfortable? Like the allegation that the judge laid out in the ruling is that Tim Cook, the CEO of Apple, was told by one of his employees, hey man, you probably shouldn't do that. It's against the court order. And he said, cool, thanks. I'm going to do it anyway because money. Like, I'm oversimplifying, but go read it for yourself. I'm not really oversimplifying that much. What does it say about these companies in particular? Does that create any unique need for legislation, any unique need for really strong penalties? Like, do people need to go to jail, like, to make any of this stick? Like, just any thoughts on the comfort level of ignoring court rulings? What does that mean to you?
So I'm going to be careful here. I'm not going to wade into the substance. Obviously, again, if I were still on the Hill, I'd be telling whatever boss I work for, hey, this might be a problem. Maybe we should do something about it. Mm-hmm. But I will say that as a law enforcer, right, when you see parties appearing to flout court rulings, to ignore verdicts that you've obtained, that just increases the scrutiny and concern, right? And you definitely become worried about repeat offenders. And there's a concern of like, if they're ignoring this, what else are they ignoring? What else don't we know about? So it's very concerning.
So looking ahead, getting back to tech again, right? A lot of critics of antitrust enforcement say by the time you figure out the case, the signs of new competition that's going to disrupt the incumbents is starting to show, right? There's an irony in that. And an example you're starting to see on this is that for the first time ever, Google just announced that their search traffic on the Safari browser, which is Apple's browser, decreased. And the reason for that is the rise of ChatGPT, a competitor, and other AI search engines. You also see folks saying, well, like when they brought the case against Meta, TikTok wasn't as cool as it is now. And now TikTok's super cool and right, like new competition. And there's just this challenge in a market that moves very quickly that by the time anything gets resolved, things have changed so much that like the case might not even make sense or that remedies have to be changed. And now looking at AI, I watched yesterday, we're recording this on whatever day it is today, but there was a hearing in the Senate with Brad Smith and Sam Altman of Microsoft and OpenAI respectively, talking about just how fast everything's happening. There's going to be societal disruption. We're going to need to like reskill people, right? And it got me thinking, if cases are taking 5 years, and legislation is tough because it's Congress, do we need to fundamentally rethink how antitrust even works? Because I know you said earlier, like, more enforcement, be more vigilant. That makes sense to me in a fast-moving market. Maybe more resources, right? Like, there's an argument to be made that more attorneys, more funds, right? When you have $300 million agencies going up against $4 trillion company, like, that's tough. But just the speed of AI, you're in this seat now. Is there something fundamental that needs to change to deal with the potential disruption that is coming?
So I think, at a high level, right, we see this raised frequently as an objection to antitrust enforcement at all. It's usually in the context of like dynamic markets, dynamic competition. And that's the idea is, hey, by the time you catch up, the market's already changing. See, it's dealt with it itself. I kind of think of that as saying like, well, this person was murdered, but it's already happened. We've all moved on. So why bother prosecute the person who committed the murder? Like the law is on the books and we're tasked with enforcing the law.
Everyone's over it. It's fine.
Yeah. So like we have an obligation to enforce the law. And as I said earlier, part of that is putting down precedents that can help protect the markets in the future. But you can't, I don't think you can, I'll tell you this. If you came into my office saying, well, the market's moving so fast that all of the ways we're screwing over customers today are going to be eclipsed by the ways we can screw them in the future. Like that's not going to be persuasive to me. There's also concerns too, right? That the pace of innovation and the manner in which innovation takes place and sort of the structure of markets and who the incumbents are and who's going to lead in the future markets very much depends upon the nature of competition in that like initial market, right? So we see AI building off of search. The important questions to be asking in this are, not like, well, this is AI going to render competition in the search market moot? Like all those concerns don't really matter because look, it's been taken care of. We're moving on. Okay, but what if we had a competitive search market? What if we hadn't had this exclusionary conduct? How much sooner might we have had some alternative? Or who else would be in the space that would have a foothold where they could actually compete, from which they could pursue something to eclipse Google faster, right? Pursuing whether it's AI or who knows what else, right? I know this is often accused of being the nirvana fallacy of like, well, things might have been even better. But that's how antitrust law works is what's the but-for world, right? And part of the harm from antitrust conduct is you don't know. You don't know what innovation was killed in the womb. You don't know what developments and competitors never got a foothold when you have this exclusionary conduct. That's why we're tasked with stopping it. That's why this is about the free market, right? It's about allowing those other options to actually emerge for consumers to make the choice about what should succeed. And you don't get to that step. You don't get to the free market operation if one company is allowed to take advantage of their position and foreclose competition.
A lot of the concerns about tech from left and right, I'm curious if you think antitrust might have addressed them or how this world might have looked differently. And understanding it's a counterfactual, I'm not asking you to like say for sure that something would have happened or not. But censorship's often brought up as the example on the right. But there's increasing concern in Congress across the country about the impact that technology has on children, both in the terms of obscene and indecent conduct, but content rather, but also just social media algorithms, right, and the addictiveness and there's all sorts of concerns about the technological impact on children, on privacy, right? That all these companies are collecting all this data on us. They can use it to target. What if it gets, data breached and all my sensitive information's now on some Reddit thread that everyone can comb through it and use it against me? All these concerns, notwithstanding the benefits of technology, I'm not pretending like I don't use Google Maps every day. Are there issues that you see being debated, right? You're a conservative. There's a lot of concerns from the conservative lens, from the liberal lens as well. Kids, privacy, data security, addictiveness, whatever, that might have played out differently had someone stopped Google from buying DoubleClick, or had someone, maybe not even specific mergers, but just more aggressive antenna vis-a-vis tech from antitrust enforcers throughout the 2000s.
Yeah, potentially. So Roger Alford, who's the principal deputy in the antitrust division, had a great explanation of this recently about how censorship is downstream from monopoly power. And I think that's what you're describing with a lot of these harms. As you know, FTC has a dual mission. We have antitrust. We also have consumer protection. And on the consumer protection side, also concerned about a lot of these things you're talking about, right? The effects on children from some of these technology platforms. Those are sort of independent concerns, we have other legal authorities that potentially allow us to address those as well. And there's no guarantee that if there had been multiple competing platforms in some market, we might have had a better outcome. But maybe, right? Like it certainly is much easier for a company to get away with conduct that harms consumers when they don't face competition, right? That if you have a platform that is built on addiction and has all these harms to children, you want to think, well, maybe if there'd been an alternative, people could have gone somewhere else. Same thing with censorship, right? If you have a platform that's censoring speech, if you had somewhere else to go, you would expect a lot of movement from at least the people being censored, right, to that other platform. When antitrust violations foreclose those competitive alternatives to begin with, we don't even know how it would have worked out, but we've prevented even the opportunity for it to happen.
All right, so we're going to close out, and I'll offer you multiple different options of things to answer. One could be if there's anything you'd like the listeners or viewers to know about the agency you work at, or if there's something that has surprised you most being a commissioner, understanding that you've worked at the agency before, you've been in antitrust for a while, but something that maybe has surprised you most about being in the seat you're in now, or really just any final thoughts you want to share before we sign off.
I think the thing for people to keep in mind, as highly as government forces often think about ourselves, we're not all knowing. We don't often know everything that's going on in a marketplace, and we depend upon complainants. We depend upon people bringing to our attention bad conduct. And so I would encourage every listener, whether you're an individual or a company, right? If something is happening that you think is unfair or violates the law, bring it to our attention. That's the only way we can do anything about it.
Well, I think this podcast should have more listeners than it does, and that cannot possibly be explained by anything other than monopolistic and consumer harm type conduct. So I look
We'll get right on it.
I'll look forward to your investigation. Commissioner, thank you so much for joining.
Thank you for having me.
And congratulations on being confirmed.
Thank you.
Find this podcast in Apple Podcasts, Spotify, wherever you get your podcasts. If you are watching this, that means you already found it, but please subscribe to the Dynamist in whatever app you use. We are always open to hearing your feedback, ideas for guests, ideas for show topics. Email me at evan@thefai.org. And if you are a fan, the number one thing you can do to help this show would be to rate us and review us in either Spotify, Apple, wherever you get it. So please do that. Subscribe, share it with your friends. Love doing it. That's how we keep it going. Catch you next time.